Welcome everybody again to another episode of Tax Law Insiders. I'm your host. I guess we can call myself that. Brian Seidensticker. I'm CEO of Tax Law Resources, and with me again today I have Matt Abey and Randy Saunders of Nelson Mullins. And Nelson Mullins is one of the very few attorney groups that actually cover multiple states regarding tax sales across the country. Welcome, Matt and Randy. Thanks again for joining us. Well, I guess a quick recap. This is part 3 of what's going to be a 4-part series. In part 2, our last time we met, we dove into some of the worst case scenarios regarding tax sales, because as we all know, the very wrong assumption that is brought, at least to us on the TSR side, that this is a guaranteed return, it's government backed, right? None of that is true. And it's even more so that there's some really sticky situations that investors can find themselves into, even if they do know what they're doing, right? And so some of those things that we talked about last time in part 2 is multiple heirs on the property. We talked about some IRS liens, how those can be headaches. We talked about HOA liens, how those can certainly be headaches in some states. And then we dove a little bit into mobile homes and how that can be interesting, because in some state, definitely some states and situations, you may have a lien on the property or on the land, right? Or you may have it only on the mobile home, but not both, right? And we dove into that a little bit, but I think it's a great to revisit that a bit. And I guess, Matt, I want to hand it over to you to kind of let's run through that. I guess to summarize it real quick again, and then dive into that a little deeper.
Yeah, that's right. So usually, and I'll give South Carolina as an example, mobile homes and the land is taxed separately. So there are different tax sales. In fact, South Carolina has a little bit different procedure for selling a mobile home than it does selling the real property. So you may get one or the other, or you can get both. And that's going to be largely dependent on state law, but virtually every state that we see has some general rule about if the mobile home is affixed to the property. So if it has become a fixture on the land itself, usually by removing the wheels, the axles, and tying it down on the East Coast to make it hurricane proof and whatnot. So South Carolina's got a statute that talks about retiring the actual certificate of title, just like your car has a certificate of title. And if you don't retire that and go through that process, which includes recording an affidavit or some sort of notice in the real property records, well, then the mobile home is still technically separate. But that's a relatively young statute. I mean, it hasn't been around forever, and you can imagine there's some mobile homes that are out there that may predate the statute and get you into this kind of gray area, and you really don't know until you go and look. You actually crawl under the mobile home to see if it's fixed. And check the real property records. So when you buy a piece of property that's got a mobile home on it, you need to make sure that you own the mobile home, because otherwise you can get yourself into some trouble, especially if you go in and try to take possession of the mobile home and you don't own it, or worse yet, you drag the mobile home off the property and get rid of it or sell it or something like that. Somebody comes back from a long vacation to find their mobile home gone, then you got an issue. And of course, in those situations, there's some invaluable, priceless jewels and family artifacts that are in the mobile home that disappear. And
a couple Vandos.
Yeah. Some spare bonds. Yeah, exactly. That disappear. And that claim gets very expensive. So knowing your state and knowing what the process is for getting rid of a mobile home title is important. And then, if you're in a situation where you do own the mobile home, you might want to retitle it and sell it separate. That might be part of your exit strategy, that you like the vacant land that's worth more than this old cruddy mobile home that's on it. So there's a process in place to retitle the mobile home, so then you can move it, get rid of it, and do what you need to with it. Of course, largely state specific, but you're going to have those issues in most of the states that we practice in.
So let me sorry, Randy, go for it.
No, I was just going to say, can I add just a few things just on this specific line with regard to mobile homes? And I think the first thing is, when you look at whether or not it was a fixed property, there are a lot of jurisdictions that I practice in that can become a fact question, which when you're a lawyer, that's the worst case scenario for trying to resolve something quickly. Because what that means is it's not a legal issue that the judge is going to be able to come in and say, oh, XYZ, it's a fixed, here we go. You actually obtained possession of both the real property and the personal property because it's fixed. Instead, you're going to have a list of things and divide it up to say, okay, it's more likely that it is affixed to the property if, like Matt said, the wheels and axles are off. If there's been cinder block foundation laid, does it have a deck or a porch that's tied into the property? And start looking at all these questions, but all of that then has to get litigated, which takes two things, time and money. I think the other thing you look at in a lot of the jurisdictions where Matt and I are probably most familiar with in the Southeast, a lot of times what you see is a split parcel situation where you have a larger family parcel and then you have a piece of the parcel that is split off for maybe the son, the daughter, the uncle who, has a nice mobile home that comes in, and you may have, a couple of these where, so it literally becomes like a family neighborhood situation. For whatever reason, you've got an issue at the taxing authority, the assessor, maybe it doesn't get split correctly. Why that's important and why to do your research is because those are nightmare situations, because you got mom and dad and the sister here, right? You've got maybe brother's trailer that he thought was okay. And like Matt says, the worst case scenario would be maybe he's in the service, or maybe he's running up and down the Mississippi on a tugboat. Like he works 6 weeks on, 6 weeks off. He comes back. You've got the property up for sale. His trailer's gone. Mom and dad are up in arms, sister's up in arms. They're going to fight you tooth and nail regardless. So you're going to put a bunch of time and money in. But then worst is what Matt referenced, what we call a trash out situation, where when you've hauled this off, you've gotten whatever resale value you could out of the mobile home itself. But most likely what you did is you went in and you trashed out all of the belongings before you took it off the property. And that's where you start losing the Van Goghs and the priceless works of art. I had one time where the couple that lived in the house had to have what I can only describe as the most priceless comic book collection known to man. It was like they went through the Overstreet price guide and just picked out every comic that, and they had thousands of these comics. And again, then you end up in a situation, which is the last situation any of our investors want to be in, where you are litigating one, whether or not it was a fixed, bunch of questions, and then it becomes almost like an insurance claim where they're telling you all this list of all this stuff that they have. And I guarantee the guys that went in and trashed this out for you didn't take pictures. They're not going to be helping you. I mean, they were acting as your sub agent, and so they're going in, they trash it out. So you don't really have a first line of defense. And we're just arguing, and they're going to bring witness after witness, mom, dad, sister, uncle, who are going to testify this is the greatest comic book collection that was ever assembled, much like the Avengers. And you're going to spend a year and a lot of money, and now you're not just trying to get out of this, you're trying to get out of this without losing your tail. Because if it comes down, and these are the ones that are horrible, because one of these, if you don't do your research up front, you end up with one of these properties, it can literally very easily wipe out all of your return for an investment year in that state. Because you're going to be tied up in litigation, and you're going to be fighting to not have to pay these people, absurd amounts of money for what was taken out of their mobile home. And that's setting aside the fact of you took their house and it's gone and you sold it. So what are you going to do with that? So it seems like this is a very innocuous situation on the front end. Hey, we're just going to go buy this property. Oh, there's a mobile home on it. Oh, we'll get that off there. When you go and you look and you decide, I'm gonna bid on this. Those are some of the questions that I think you need to make sure you're asking yourself on the front end. Go and look and make sure that the DMV title has been retired. It's been released. That this is all now subject to that it's all entirely the real property.
Got it.
Because, if not, you're going to be in trouble.
So if you were, maybe I'm oversimplifying it, you guys can help me clarify that. But if you were to rank, I'll say best to worst scenarios, right? Best being, you bought the lien and it is the mobile home and the property, right? Very clear. Right, that's a very clear situation, just like any other real property. And then you've got two other scenarios, right? When you only bought it, and it happens to be only the land, and then one where it only happens to be the mobile home. Is there one of those scenarios that's better than the other, or are they both equally bad?
Well, I would say where you buy the land and don't own the mobile home is a little bit stickier situation, because then you got to go through the process of identifying who owns the mobile home, which may or may not have been the landowner. You got to make sure that you've let any other lien holders, you've identified any lien holders, because usually that's a separate financing deal that's done when somebody purchases one of those. And then you got to figure out how to get it off the property. Because you can't just bring a truck on there and haul it off, and it's not like you just set it on the side of the road for the trash guy to pick up. I mean, you gotta have somewhere to take it. So I would think that scenario is a little bit more dangerous for you, because you've got to go through the process to name everybody in some sort of lawsuit, give them notice, and then get direction from a court about what to do with this mobile home. Because otherwise, you're gonna potentially have some claims, not just from the people who own it or have an interest in it, but then the county might be upset with you, or the city might be upset with you because you just moved it off the property to somebody else's land.
And Matt, you mentioned something that I think is important here too, because, you know, when you look at, we've got clients that finance for mobile homes, right? And so that mobile home is their secured collateral, right? And when you purchase this piece of real property, assuming it's not a fix, then you wouldn't have seen them, because they're not going to have, and I believe this is an accurate statement, man. I mean, it might not be accurate in all statements, but in all states, but the lien is going to be on the collateral, not on the real property, because they don't have an ownership interest in the real property. So now you think you've got it, you move it off. Now you don't only have a claim against, or a claim being filed against you by the individual living in it, but you've literally stripped the collateral that the financing entity has, and they will come after you. Yeah. So, and I'm not sure, between mom and dad, trying to protect their baby boy, and the financing company, trying to get back what they can when you've stripped and trashed their collateral. Again, just not a good situation to be in.
Got it. And you're talking about the previous owner having a loan out on that mobile home, right?
Yes.
Got it.
Yeah, because usually it's like family land that somebody has, and then Bobby Joe buys the mobile home and finances it. Right. So they retain that. They file something usually with the Secretary of State or whoever handles the Uniform Commercial Code filings, so that they have a lien on the mobile home. Might be with the local DMV or something like that. So there are a number of different entities that might have an interest that could come after you in that scenario. So that's why going back, due diligence is so important. And we realize it's not feasible to search every single property that you're looking to bid on, and to make sure that they're, go out and see if there's a mobile home on every single one. But there are some things that you can do, such as you can look at the real property records, maybe to see if there are any recorded retirement of certificate of title documents, so that you own the mobile home. But it might be as simple as just checking the county tax records to see if the same owner is also being taxed for something else, because that's a good indication that they either own other real property or they own other types of assets like mobile homes. So you just factor that risk into how much you bid.
But it is really a landmine in waiting, because again, if you've done your research on the real property, but you haven't gone down the road with the mobile home, when you pull that off there, you're not going to have any idea of what happened until 3, 4, 6 months later, when they show up at your door and they're like, you literally pulled our collateral off of this land. It's long gone now, and so they're going to come after you for whatever was left, on that note. and again, that's why I think when you look at these situations, to kind of piggyback on what Matt said, if something looks too good to be true, you've got a bunch of properties on a nice golf course, you might need to look a little bit closer in South Carolina before you jump in there. If you've got these properties up here, and you see that it's got mobile homes sitting on it, to Matt's point, you don't have to dig in every situation, but know the ones that could potentially turn into landmines that could then impact your entire return for that investment.
Yeah, and so to just kind of summarize the best to worst again, best being you get the lien on both the land and the mobile home. Next one being a lien on at least the mobile home, right? Or and then worst being just the land, right? And there's certainly things you can do to know at least what you're getting yourself into, right? You can certainly send, and there's services out there that will do inspections, photos, right? Drive-by photos on properties in mass, right? At a relatively inexpensive price compared to these headaches, for sure.
Right.
At least you would know what you're getting yourself into. Doesn't mean that they're worthless in every case, but knowing what you're getting yourself into and at least avoid it, or go in there with eyes wide open, not blind, is definitely key.
Because I tell you, the inside joke is when somebody comes to you and they're 6 or 8 months down the road and they have trashed out everything in the mobile home and it's gone. They pulled the mobile home off and it's been sitting in a dump or whatever for 8 months, and they're like, hey, we need your help. And like, do you have a time machine? Because I like, these are things we need to look at, because I can't refurbish the mobile home for you. That's really not my skill set. And we're not going to go dig through the dump to find all this, and obviously these are claims that we can help you litigate, but it's not something that anybody is going to look at and be like, oh, this is an easy fix. The front end due diligence that we're going to talk about, I think, next time, is really what helps prevent these situations. Because the bigger issue too is these landmines don't explode immediately when you step on them. All of these things are going to work. It's going to take some time, and then it's going to come to a head 6-8 months down the road. And by that time, it's an absolute mess.
You bring up a good point. I guess it's not an immediate landmine, right? So it kind of depends on what you do at that instance when you do end up with owning, that just the vacant piece of property, right? Not the mobile home. Is it safe?
There's no way to call us until the mobile home's gone, all the property's gone, the financing company is suing you, the mom and dad are suing you. Try to get to us before that point.
I was gonna say, is it best if you find yourself in that situation where you now own at least a lien, or you have ended up with ownership on the piece of property, do nothing, right? Reach out to you guys and help formulate a plan to move forward from there. That's much better than after the fact.
Yeah, because it's not a hugely complex, a long time ordeal. We can look at that pretty quickly, determine, like Matt said, we can look at the UCC filings in that state. We can look at how it's being taxed by the taxing authority. Is he being taxed on personal property and real property? We can find out, who has what interest in what. We can find out if that personal property, the mobile home, is actually still secured, and figure out who the financing arm of that is, who's servicing that loan, pull all of that stuff together, come up with a plan about how to proceed. And because here's the other thing is, you might not be entitled to pull that guy off the land. You may own it, but you may be in a position where, we need to structure some kind of landlord-tenant relationship.
Because they have rights too, right? That's depending on the state.
Right.
Now, I guess what is piquing my curiosity, right? And I would have thought it was opposite, right? It's better to have the land because at least you own something, and it's you guys stated it's actually slightly better, at least from a risk standpoint or landmine standpoint, of having on the piece of, or on the mobile home itself. So I guess you end up owning the mobile home and not the land. I guess help me, what are your options in that instance, right? Are you forced to move it at that point, or I guess you now have the same rights that it's an opposite, right? They can't just go move your mobile home.
Matt, I'll say my situation's been, the only time I get the mobile home that I could think of is if it is a fix. Like, that's usually my kind of, it's like we have the mobile home because it is a fix. So I'll toss this one to you. If you've got situations where you actually acquire the mobile home and not the actual real property on which it's at.
No, so in those situations, it's largely going to be dependent on what kind of relationship the owner of that mobile home had with the owner of the land. Usually there's some sort of ground rent or ground lease that's involved. And that'll set out the terms and conditions on, accessing the mobile home, moving it, what you can and can't do with it. So it's largely going to be dependent on that previous relationship. And you've got a situation where you don't know if you actually step into the shoes of that prior owner. So that's one. It's going to be dependent on what's in the agreement already. And that might be another situation where you want to, if you see this scenario, you want to press pause, try to figure out what your rights are, work with the landowner themselves to try and move the mobile home, or do something of the sort. So then you can, of course, monetize that asset. But it's not something where you just try to go in the dead of night, put the axles back on and drag it off, because it might
Keep
be
a couple axles in the back of our truck just in case.
Yeah, exactly.
One-stop shop.
Right. So that might not be the best time to go out there and rely on some self-help. Check the relationship, the business or contractual relationship you have with the owner under that ground lease or ground rent agreement.
Excellent. Okay. Well, we spent lots of time talking about mobile homes, which I would have never thought to be as many sticky situations you guys mentioned there. So hopefully the listeners found that intriguing as well. But let's shift a little bit and talk about statute of limitations, which can be good and bad, which is kind of a two-ended story, right? There's how long you have to wait until you start any sort of foreclosure proceedings, and then how long do you have, right? Which a lot of people aren't aware of. There is a limitation in many states of you have to do it in this time frame, otherwise your lien is worthless. So I guess Randy, why don't you kind of start us off on that?
Do you care if there was one other thing I just thought of that we hadn't talked, which is phantom properties, and then it leads into this.
Okay.
Because you also have a limited period of time to address these, and I'll be quick on this, but the other thing that due diligence is important is on a lot of these tax rolls, they have these phantom properties that, say you had a family plot and, 30 years ago, the highway ran through them, right? Split it up, but for whatever reason, it's a smaller county, that parcel didn't get taken off of the tax rolls. And so what happens is every year that property goes up as delinquent. Some people may get caught up in it, okay, I'm buying a bunch of these, right? So I'm just going to go down the list. I'm going to purchase all these properties. They don't do the due diligence to kind of go out there and figure out, well, okay, this parcel can't possibly exist because there's a 4-lane that runs right through it. The sticking point in the vast majority of jurisdictions that I'm aware of puts the onus on the purchaser, and they give you a certain amount of time to contest this and to come back and say, hey, you sold this to me. It's a phantom parcel. For whatever reason, it's still on the tax roll. I need to be refunded. And the refund mechanism is going to be different in every jurisdiction about exactly what you're going to get back in the timing that you have to do that in. But I think that's another important, because that can be a mess too. You get them, you set on them, you spend, now the nice part of that is your damages are ultimately going to be capped, because there's really nobody on the other side that's going to be damaged or offended by this. But if you buy quite a few of these in a county and you've got a stack of phantom parcels, you've just absolutely wasted your money. You have no recourse. And if you don't step in and talk to the proper authorities in time to get that refund back, you're done. There's no judge that I know of that I'm going to be able to go in front of and say, I want to take money back. I didn't do my due diligence. I didn't get this in time, but judge, I want you to make a special exception to me, take money from the school board ultimately. And, those little kids don't need their books. Give me my money back that I bought these phantom parcels for. That's a very difficult situation for us to win.
Yeah, and you mentioned a 4-laner going through an old parcel. I think the most common one I've come across is similarly a developer building townhomes. Well, they'll have plans for so many townhomes and they get it parceled out as such, and then somewhere along the way the plans change, right? And the records don't get updated, and you end up with a number 405, and number 405 doesn't actually exist anymore.
Right.
And those are things to definitely watch out for, because like you said, counties leave it on the investor. It's up to them to figure that stuff out. Interesting.
Yeah,
So
with the townhomes, those can be super, it's like if you're looking at what you think is a vacant parcel, versus like the situation you're talking about. I mean, you could have a lot of money tied up in some of this. So it can be pretty significant. But again, that's why that's something you just want to keep on your list and at least have a process in place to, and I know it sounds crazy because you think if I'm going there, but it's a buyer beware situation. And the county's simply selling what's on the tax rolls. And if there is any kind of issue with it, you have to bring that to their attention. So, make sure you do your due diligence and know what you're purchasing.
Exactly. So speaking of the statute limitations in those cases, at least in the states you guys are operating in, do all of the states allow you a period of time to, get a refund on those if you do learn it after the fact? And I guess roughly how long do they give you?
Go ahead, Matt, if you want.
Yeah, I was going to say one of the states that we have done some work in, of course, is Alabama. And Alabama does have a statute where if the tax collector or revenue commissioner or probate judge has failed to do something they're required to do by statute, you have a cause of action against their official bond that they have to get when they're elected and put into office. And off the top of my head, I want to say it's like 5 years. But that's a period that doesn't get extended, and you actually might have to sue on that before you know that somebody has come in and contested the tax sale. Because remember, in Alabama, you've got generally under the old tax deed statute, you have a 3-year time period before you actually get the tax deed. So knowing early whether or not you've got a valid or void tax sale is important. Because it might limit your ability to go back and get money from that county official who failed to give notice to somebody that was very obvious and should have received notice. In South Carolina, by contrast, it's not really a statute of limitations, but it can be treated as such. The county tax collector has the right to void a tax sale up until is using his discretion or her discretion to void the tax sale because of some failure to send notice or some other issue that impacts the validity of the tax sale, but only up until the point that the tax deed is issued. So it's roughly 1 year from the tax sale. So once you've already got the tax deed, you're essentially stuck with it. Although you could go through the court system to have it voided if there's truly an issue with it and somebody's contesting the validity of it. So that's a pretty short period. So that goes back to what Randy and I have said from the beginning, is getting out in front of some of these issues is the way to avoid having a bigger problem later on down the road. So that's just a couple of examples of where if you don't act quickly enough, you might not have a recourse against the county. But another example is in Alabama. Alabama's got a 6-year statute of limitations from the date of the tax sale for you to actually take possession and eject people from the property in order for you to later get quiet title to the property. And if you fail to act within that 6-year period, then your interest just evaporates. It's gone. And you've got no recourse at all, whether it's against the land that you bought, whether it's against the taxpayer or the county. So making sure when you buy this, a piece of property that you're noting in your calendar, you're noting it for attorneys in our docketing system when the statute of limitations is, because you got to file before then, and then get service on people so that it's a valid lawsuit in order to protect that interest. And that's even more important. I would say, when you go to the tax sale and you're the first purchaser and you're buying it from the county, you know that date, you know what you bought for the most part, and you can very easily docket that date. But when you're buying on the secondary market, you're buying a tranche of these from somebody, you need to make sure that you're confirming this was bought at the 2016 tax sale, and I know that I've got until the sometime in 2022 to file my lawsuit and to start the ejectment proceedings, because you could have situations where the tax deed was issued well after the fact and you're going off the tax deed date rather than the tax sale date. So don't miss those deadlines, because you can't go backwards. You can't get that time machine like Randy was talking about and go back and file something retroactively usually.
Now, it's real quick on that note, and the 6-year limitation in Alabama, and I know there's some states where your right to foreclose is extinguished, meaning like you've got I call them lottery tickets. I guess lots of names out there for them. potentially, and typically, interest stops accruing as well, or may still accrue, but at a much lesser amount. Now in Alabama, I know each state's different. In Alabama, at that 6-year mark, is that lien essentially extinguished? And like Florida's probably a better example. After 7 years, the lien's extinguished, just like it never existed. Is it same way in Alabama, or is the lien there just no more interest? You can't foreclose. What exactly changes there?
Yes, so attorneys in Alabama haven't gotten creative enough to yet try to argue that it survives, the lien itself survives after that 6-year period. But there was a case, I believe, maybe 2 years ago, that said that the interest is extinguished, it's gone, and you don't have an interest in the property. Now, there are statutes on the books that talk about where you've got some sort of invalidity in the tax sale or something. There's an assignment of the lien from the county, and you actually inherit not just the property, but the lien itself. And so you might be able to get creative and argue that the lien somehow has that validity on past that 6-year mark. But I would imagine, based on the language used by the court in that 6-year case, that it's gone and you've lost it.
So it may not be a case, but certainly not recommended to try and test that.
Right.
I'll take a quick step back into the ability to challenge or request a refund on those. I'm going to call them a sale and error. I know that's not the term used in every state. Illinois uses that. I think Arizona uses that as well. But these sales on parcels that don't exist. I guess, Randy, are there any states that you work with that don't allow you an opportunity?
Oh, no. And so I think most of them that I'm familiar with, you're going to look at about around that 1 year mark. And the longest one that I can think of is it would be around 3. But traditionally, I think, and Matt's point too is well taken. If you're the original purchaser, or if you're looking through a portfolio for purchase, all of these points that we're talking about, are worth examining, because if you've got a lot of dead weight in that portfolio, the issues we're talking about are exactly what's going to be causing that dead weight, and you don't want to purchase those problems. But yeah, going back to the timeline that you have to bring that to the attention of the official in the state that can take an action to reverse it. Well, again, what I'm most familiar with, like in West Virginia, you're going to need to bring that to the attention of the county within that 1 year period. If not, then you're out of luck.
Got it.
And so when we're looking at the regular statute of limitations, just on proceeding with acquiring like a tax deed or hopefully insurable interest, I think that the two different formulas that states employ is in some states you have due process before title is issued, and in some states you have due process after title is issued. And so that's what you're looking at. So in West Virginia, you get your tax lien from the sheriff. You have to wait 18 months. So you get it in October or November of 1 year. You wait all the way through October, November the next year, and then you come to March or April of that following year. At that point, you can walk into the county and you can get issuance of a tax deed. So that's now your property pursuant to that tax deed. Now, there was that redemption period, but the due process part in West Virginia really continues for 3 years after the issuance of that tax deed. And it's going to say, all right, at that point, what happens is if anybody comes out of the woodwork and says, I didn't get notice, I am an individual or an entity who should have had a chance to redeem. I wasn't given that chance to redeem. They can file a lawsuit for up to 3 years and try to set aside the issuance of that tax deed, and then you have to redeem. And you can get that statutorily you can recover a lot, but at the same time, if you're at year 2.5, one, do you even still have the property? Did you sell it, flip it? Two, did you fix it up? Is it rental? Have you put a lot of money into it? So you want to make sure either if this was an original acquisition or if this is one you picked up through a portfolio, that you have all the documentation in place, so that if it does get challenged, you can show, nope, everything went out. And I'm keeping that. And it's, that's having that paperwork and being able to show the judge that will shut it down quicker. If you don't, and really a lot of times that's what it comes down to. Did you send this person notice? Show it to me. Show me the green card. Show me where they received it. Because it's going to be strict construction. A lot of these states have moved away from constructive notice to where they want actual notice, and they want notice on the property and notice on the individual. So that judge is going to say, show me, and you got to remember, in West Virginia, you've got, a resident of that county that, everybody knows each other. And so, when he gets up and tells the judge, hey, I didn't get notice, as opposed to being some out-of-state entity, he's going to believe that individual that he's known his entire life, so you better have something that you can show that judge, no, I sent this letter, I gave notice, they didn't do it. And so, I think on other states, for instance, if you look at Kentucky, it's an entirely different, we've covered that before, entirely different process. There you are foreclosing on your lien and you're moving to sell the property at foreclosure sale. But there the limitation period is in that first year, you can't do anything. And then you've got 10 years after that. If you don't do something at that point, that lien expires. So again, if you're looking at a portfolio, and sometimes in Kentucky, those portfolios can be really weighted down at the end. You're getting a ton of them, but you got a lot of that 6, 7, 8, 9. You got to know quickly, what do I have? Is there a reason? Is it garbage? Is that a reason that nothing's been done on it? Because, one, it's not worth taking a foreclosure sale or whatever. But two, how fast you have to act before those liens are going to expire. Because at that point, those liens become null and void.
Worthless, right? At that point. But it's similar, as Kentucky's similar to Florida. Florida 7 years, Kentucky's 10, and the lien is wiped out. We don't have to cover every state, but what are some other examples? In South Carolina, as far as the minimum and maximum, how does that work, Matt?
Yeah, so there is a statute that's in place that talks about how long a county has to assess taxes or then collect on the taxes. And then there's a statute that says how long you have to contest the validity of the tax sale. But there's no statute directly on point saying that you have X number of years to file to get quiet title or something of the like. Because remember, South Carolina is mostly an administrative process, beginning with the county official auctioning off the property, giving the notice. And then there's a court component in the sense that you file the quiet tax title action later on down the road to clear out other interests that might be there. But there's no statute saying that you have a particular time limit. And that might make you feel good that, hey, I bought this tranche of properties and there's no time limit. I'll just get to it whenever I get to it. But one thing you got to keep in mind is that every state generally has a catch-all statute of limitations that's out there. And it says something of the effect of for no other, for any other claim or civil action that for which a statute doesn't prescribe a specific statute of limitations, it must be 5 years or 10 years, whatever the case might be. There are also statutes limitations for collecting on a penalty or something of that nature. And a court could liken a tax sale foreclosure, tax lien foreclosure, or quiet title action as an action to collect on a penalty or something of the like, and prescribe a statute of limitations, even though there's nothing in the tax sale statute saying that there's a particular statute, so or statute of limitations. So it again, acting with diligence and getting out in front of these issues usually is the better play rather than just letting it sit, because the longer it sits, it usually doesn't get any better for you.
Right. Well, it's interesting to know that most people, savvy investors, right, to do their homework, they'll read the tax sale statutes to get familiar with those as well. But as you just stated, sometimes that doesn't have all of the answers and doesn't really encompass all of the situations that can arise. So another great example of always good to reach out to a local attorney like you guys to help with those questions. To kind of, I guess, summarize is probably an understatement, but as far as worst case scenario with the statute of limitations, one, knowing what you bought, right, and having, at least in the states you guys work with, you do have a period of time, and you mentioned a year is not real long, right, and it isn't, right, but it certainly is long enough to figure out what you bought at the sale. And I hear complaints all the time of Well, it's just not economical. It doesn't make sense to hire somebody to do inspections on all 1,000 properties prior to the auction. I'm only going to end up buying 20 of them or 50 of them, right? That may be true, right? But that doesn't eliminate the certainly the fact that you've owned these 20 or 50. You now have, it sounds like at least a year to go out and figure out what you just bought. And if you bought something erroneously, you have the opportunity to fix that. Don't wait too long and don't ignore it, because waiting too long and ignoring it are what ends up in those worst case scenarios that we talked about. Randy, Matt, I'm sure there's a ton of other scenarios we can run through. I apologize, we're running out of time for today. We definitely want to circle back. We'll call it part 4, but we'll talk about some of the remedies for these worst case scenarios. Working with you, doing research. We talk about all the time, doing your due diligence, knowing what you're buying. So we'll talk about that in part 4. I thank you again for your time and joining us, and hopefully everybody listening got as much insight as I did.
All right, thank you. We appreciate your
Thanks.
time.
All right, take care, guys.